SJC-11608, Bay Colony Railroad Corporation, the town of Yarmouth.
Good morning. Please proceed.
Good morning. May it please the court, my name is Joseph Tehan, and together with Jackie Cowan, I represent the town of Yarmouth in this matter. As the lower court correctly instructed the jury, a contract is unenforceable if a contract calls for illegal performance. Here, the plaintiff's proposed trucking of trash from the Yarmouth landfill is illegal for two reasons. It is prohibited first by state statute, General Laws, Chapter 160, Section 70A, and further, it is prohibited by the terms and conditions of the operative DEP landfill permit. Because the plaintiff was legally unable to perform its obligations under this contract, it cannot recover, and the judgment entered in its favor should be reversed. Specifically, the state statute is General Laws, Chapter 160, Section 70A. And that statute prohibits trucking by railroads in areas outside their rail service. The lower court correctly noted that this prohibition speaks for itself. And here as well, there is no question that due to its loss of a rail lease that had been issued to it by the Commonwealth, the plaintiff no longer had rail service in the landfill area.
Right.
Explain why that's not preempted.
Right.
Yes. The reason is, although it does deal with an issue of price, route, or service, Justice Cordy, it would be a good opportunity perhaps for me to reference a new case, and I'll proceed from there. It is called Dan City Car Sales versus Pelkey. It's a Supreme Court case at 133 Supreme Court 1769. In that case, the Supreme Court made clear that the preemption section of the Federal Aviation Administration Authorization Act contained what it called an important qualification. The addition of the phrase, in addition to the prior language of regulating a price, route, or service, the phrase with respect to transportation of property. Now, in the Dan City Car Sales case, the Supreme Court analyzed very carefully and with great scrutiny that language. And in that particular case, they found that the transportation element was lacking and found, therefore, that there was no preemption. In this instance, the property aspect is lacking, and that is why this state statute is not preempted.
You mean because trash isn't property?
Trash is not property, Your Honor.
One man's trash, another man's treasure? No, it doesn't.
Well, that's another way of looking at it, but I think there's always been a distinction between things of value and trash. And
Well, trash can be burned. It can be a source of fuel. It can be recycled, or some of it can be recycled.
That's what it was intended for here.
This is
I mean,
all true.
electricity.
However, if I may, of course, our touchstone in our analysis of whether preemption applies is congressional intent. And here, I think we're fortunate that we don't have to divine whether there's an occupation of the area or anything like that. There is an express preemption clause, and my argument derives, and a significant case upon which I rely derives, from the Joint House Conference report underlying the the FAAA statute. And in that, it is clear that Congress did not intend, for purposes of preemption analysis, that trash be considered property. Now, the AGG case that I've cited, I think that was Second Circuit, also embraced that House report as clearly indicative of the congressional intent that property not be regulated, that trash
Was
not
that
be regulated.
in the context of trash trucks going curb to curb to pick up garbage?
There was reference to trash
that's because overall concern, of course, is the interstate intersection and regulation of making that an even playing ground for trucking as compared to aviation. So weren't they really dealing with house-to-house garbage trucks?
I don't think it was, there's a reference to that, but I don't think there's a real express limitation on that. And I think you have to look at the continuum of trash disposal. It's picked up at your curb, it's taken to a transfer station such as this, and eventually is trucked to, in this instance, a place where the refuse was burned, produce energy. So I think the salient analysis is not the particular stage of the process, but rather what is being dealt with. And I think we have a continuum of trash disposal that starts at your curb, and in this instance ends at the site where it is burned for fuel. So I think the nature of what is being carried, rather than the stage of the process, is what controls.
So your position is that if the Federal Aviation Act statute did not have the phrase "with respect to the transportation of property," it would be preempted?
I think I concede that. I've tried to present a very precise argument, and in this instance, I think there is an interplay between the state statute and price route and routes, because you can't do it in that area. However, what struck me about the Dan City case is this is not superfluous language. It's something that the Supreme Court looked at very carefully. And therefore, yes, the argument here hinges upon the fact that trash is not property, Your Honor.
So that means then that a railroad is allowed to transport by truck anything outside its area except trash?
No, Your Honor, not at all. I'm sorry if I led to any confusion in that regard. The state statute gives just about the vaguest breadth to the prohibition possible. It talks about freight. Now, in this instance, because we're called upon when we undertake a preemption analysis to be very fact-specific, to deal with things in context, the entire case is trash. So it is our position that the state statute is very broad, and it prohibits railroads from transporting anything outside the areas in which they have rail service. In this instance, that anything happens to be the trash, which is not preempted expressly by the state.
But I thought you said that all but trash would be preempted.
I'm sorry, Your Honor.
I thought you said that all but trash would be preempted.
Oh, I'm sorry, perhaps I didn't speak clearly. In this instance, I am saying that the transport of trash is not preempted, given the House report and the case that followed it. The state prohibition is broader than that, and this just fits within a general prohibition about trucking freight outside areas where you have rail service.
Okay, but I'm losing you. If Bay Colony said we're going to transport cranberries from the Cape, and the state came in and said, no, you can't do that under 70A because you no longer have a rail line on the Cape, would that be enforceable, or would that be preempted? In
that instance, I think it would lean toward preemption. Again, I go back to the nature of what is being carried in the context of this particular case, the trash.
Okay, so then they can't carry cranberries. I'm sorry, they can carry cranberries, they can't carry trash.
Well, yes, because the specific context, the specific subject matter, what brings us here, the nature of what's being carried is the trash, which the framers or the Congress specifically determined was not to be the subject of preemption. So yes, it is a narrow argument based upon the House report and the AGG case in that regard. It's our position that what happened in this case below is that the first attempt to nullify Chapter 160, Section 78 by a preemption argument occurred during trial. And the court was a little concerned by that. It noted that these are unusual issues, and it actually admonished the plaintiff, you should have done this before. And there's a reason for that, because in the somewhat rushed context of deciding a DV motion, there wasn't the opportunity really for either the defendant or the judge below to look into House history and the like. And because of that, we think that the significant portion of the preemption language, which specifically limited its scope, was never touched upon by the lower court. And we feel in that regard, that was error. There was a clear statutory inability to perform, which negates the judgment and dictates its reversal.
Do you, just as a factual matter, if I understand correctly, when Bay Colony lost its ability to use the state rails, you never talked to them, right? You just entered into a contract with the whatever the entity that is that now has the
It's true enough, Your Honor. The station was designed to work with trains. They still use trains there, and the town opted to go with the people who assumed the lease. There was no discussion. If I may, It wouldn't have changed anything because it wouldn't have enabled them to evade the scope of the state statute. So the primary argument, and I suspect the reason that the court took the case, is that we feel that the finding of preemption below was erroneous. There was a clear inability to perform, and given that, there was no breach and there can be no recovery.
On the permit question, is it your position that, well, maybe it could have been amended to be beyond 48 hours, but that wasn't our responsibility? Is that essentially
That's not unfair, but if I could expand upon that just a bit. The court below made an important ruling on that point, Your Honor. It acknowledged, and I think it's at Appendix 105, that the DEP permit governing the landfill, specifically that part of the permit which limited to trucking to 48 hours duration at any given stretch, rendered the proposed trucking of trash in this case illegal. Now, it's our position the court should have stopped there, but instead it presented the issue to the jury on an implied covenant of good faith and fair dealing as to whether, well, maybe the town could have amended this, maybe something would have come of it, maybe this could have been rectified. Again, it cuts against my primary argument that none of this matters given the state statute. But having said that, we think it was erroneous to submit the contract breach claim to the jury on the implied covenant basis. And the reason for that is the contract is pretty clear. And the parties agreed to it at arm's length and after some back and forth, one would assume. And all that the town is required to do under the contract is to, quote unquote, permit transfer of the trash by an alternate means. Now, of course, that presumes that it would be a legal means or that would be nullified. But it nowhere requires the town to take any assistance or to provide any assistance or to cooperate in any efforts of the plaintiff to amend the permit. Now, this is something that could have been inserted in the contract. The plaintiffs testified that they were aware of the DEP permit but never looked at it, but it wasn't. And the gist of our allegation or our claim of error in that regard is that per the AASH and Tefanction cases that are cited in my brief, the implied covenant of good faith and fair dealing doesn't require and doesn't permit the contract be rewritten or to create duties or rights that are not in the contract. In this instance, we feel that the court did just that erroneously. This is sort of, as to make the point clear, a belt and suspenders argument to the state statute, but we feel on that basis, again, they were unable to perform.
But what do we do with the fact that the town of Yarmouth in Section 9 said that we will consent to any party entering into a new agreement with the Commonwealth for the operation of all or substantial port, or to permit Bay Colony to continue to provide the transportation either under an arrangement with a successor operator or by other modes of transportation?
Yes.
Doesn't that indicate, when you say or by other modes of transportation, isn't implicit in that is the possibility that you would need to get that permit adjusted?
It may. I don't think there was evidence that it was a factor being considered at that point in time. But the gist of my argument, Your Honor, is that strictly in the terms of the contract, there was no requirement that the town cooperate, assist, or do anything with respect to the permit. It was really merely passive in that regard. And again,
You had to agree under Section 9 to other modes of transportation.
which is kind of vague, and I wouldn't stand here before you and think that it didn't contemplate trucking, but to read into that it imparted an obligation for the town as the permit holder to go and redo its permit, I think stretches it and I think is beyond the scope of the proper application of the implied covenant.
Well, wasn't that a jury question? And wasn't that a question that was put to the jury?
Well, yeah, but that was the whole point here. Our position with respect to the permit issue is that once it was established that, and the judge recognized this, that it foreclosed the trucking, that it was not appropriate to proceed to instruct the jury on this theory of the implied covenant. They did decide it. Our position is it was erroneous to submit it to them on that theory.
Why?
Because It reads into the contract something that isn't there, which I think is inappropriate under the longstanding
But it
case
doesn't
law.
read anything into the contract. It's something that, that the Bay State or Bay Colony is saying, look, we're not precluded from operating under, we have a reasonable opportunity and a reasonable likelihood of getting a permit from the DEP to haul trash on the roads.
I understand that that's what evolved into the argument, but again, it's straying fairly far. I think trial counsel called it handicapping the odds of whether it would be successful. The fact is that the permit had this prohibition in it. Nothing in the contract, I submit, required the town to take the extraordinary step of going back through the whole DEP process to modify its permit in order to accommodate this.
But does the town have to get a modification of the permit?
Yes.
Bay Colony isn't the one that gets the modification?
No, Your Honor, because the town is the permit holder. The town would have had to do it.
All right.
All right, thank you.
Thank you very much, Your Honor. Thank you.
Good morning, Your Honors. My name is Joel Beckman, and I represent Bay Colony Railroad Corporation. Appearing with me is Dana Zakarian. In this case, Your Honors, Bay Colony had the contractual right to transport via trucking after its rail lease expired. And when Bay Colony invoked that right in 2007, the town responded by terminating the transportation agreement and claiming that it had the right to assign the agreement to the new rail operator. In fact, on the very same day that it terminated the relationship, it purported to assign that agreement to the new rail operator. Now, why is this so important on the appeal? Because now the town wants to argue, after the fact, after the termination, after the assignment, that the DEP permit and the DPU statute did not allow for trucking.
Well, but could you have simply taken over and used your trucks? Could you have done that?
Absolutely. And the evidence of the trial is ready, willing, and able to perform.
And then what would have happened because of the permit violation?
Well, let me address that, Your Honor. There was no per se permit violation, because I think Justice Gantz was going right to the heart of the matter with respect to Section 9. We had the right to transport via trucking. The town held that permit. Only the town could seek an amendment of that permit. Now, what's unique in this situation, and the testimony...
If you were trucking in violation of the permit,
but
you'd be trucking in violation of state law.
We wouldn't, because in the fall, in October of 2007, the town, or Bay Colony, gave notice to the town, we're not going to be leasing, we're going to exercise our right to operate. The town held that permit. The town could have easily modified that permit, because we had the right under Section 9 to do so. There's an implicit obligation under the duty of good faith and fair dealing to, in fact, cooperate and help us out, because it was easily, and that's what the testimony was at trial, it was easily amended. 87 out of the 90 communities on the Cape were trucking.
So you're saying that the provision in Section 9 that gives you the, quote, the option of trucking implicitly requires the town, under the covenant of good faith and fair dealing, to make a cooperative effort to have the permit modified.
Exactly.
Or to at least seek to have the permit modified.
That's exactly right. And I think, in fact, the town relies on Gloucester, this Gloucester case, and Justice Gantz, in fact, ruled in the trial court in that case, where it was a similar situation with respect to a DEP permit. In that case, the plaintiff actually had the obligation to seek the permit. In the situation, what Justice Gantz pointed out in the trial court was the defendant didn't do anything to affirmatively block the plaintiff from performing. But that's why I started out the outset here of our argument that that's exactly what happened here. The same day the town said goodbye, good luck, it purported to assign the agreement, there was absolutely zero opportunity to address that permit issue, zero opportunity. And our point simply is, Your Honor, and that's what the trial record showed, was it was easily amended. The town had done it in the past, and the town in 2012, in fact, submitted an RFP to operate its transfer station. And how was it going to do it? It was seeking to do it via trucking. So the town knew it would have to modify its permit. So the town can't say, under the contract, under Section 9, we're giving you the right to truck, but we're going to hold this permit behind our back and deprive you the fruits of your contract, when it's an easily modifiable operation pro forma issue to do, which they did all the time.
But couldn't the contract have specifically required the town's cooperation?
Great question, Your Honor. 1989 is when this transportation contract was signed, which gave the right, the transportation contract between Bay Colony and the town. The DEP permit didn't come into operation until 1994. 5 years
After the
later.
contract, after the contract was written.
After the contract was written. I mean, lawyers can be prescient, but I don't think it can be that prescient in terms of those types of issues, Your Honor. When the agreement, Section 9, is so crystal clear with respect to the right to truck, which is what the court found in trial at summary judgment. Now, I think this is very, very important. In fact, the town is stopped from arguing that the court erred by submitting the DEP permit issues to the jury, because in opposition to our summary judgment motion, to Bay Colony's summary judgment motion, that we had the right to contract, the town successfully argued that there were material facts in dispute regarding the DEP permit. That's at the appendix at 6465. For purposes of this appeal, now the town asserts that the court erred by giving it to the jury. The town is stopped. The town can't have it both ways. And I think that's a fundamental flaw, Your Honors, in terms of what they're arguing today.
But judicial estoppel means somebody, I mean, nobody's lost any rights. Nobody's changed positions because of this, right?
Well, I just think the town, I think the record has to be, and the evaluation has to be based on the ending, the trial, the trial record. Now they're trying to craft this as a question of law, when in fact they raised it as an affirmative defense and said, hold on, this is a material issue of fact as to whether the DEP permit can be amended or not. So there's a trial on the merits on that issue, and in fact, the DEP section chief testified, as I've outlined, that it can be easily amended. The town held the permit; they should have cooperated in amending the permit.
Could you
So what do you
address
say
the
to Dan
DEP?
Cities? What do you say to the Dan Cities preemption issue?
Dan City's preemption actually addresses, there was no transportation of property there. That involved the storage and disposal. A tow truck company grabbed someone's car and stored it and disposed of it. The plaintiff brought a consumer protection claim as well as a negligence claim with respect to that conduct. The transportation of property had occurred months and months and months before. So in that situation, the Supreme Court found transportation of property isn't involved in any respect. But I think I would like to shift, Your Honor, to the preemption issue, because I think that that is critical in terms of the analysis. The FAA provides in relevant part that a state may not enact any law related to a price, route, or service of any motor carrier. And what Congress was trying to do here is to avoid a patchwork of regulations that would frustrate competition and have a level playing field for all motor carriers. And this specifically, I think it's informative in terms of the context in which this FAA was passed. Congress was concerned that package delivery services, companies that were organized as air carriers like Federal Express, were preempted under the ADA, as opposed to UPS, which was a motor carrier, were not preempted. So they wanted all motor carriers to be treated equally and have the same, the same level playing field. And I think that's important here, Your Honor, because The town basically argues that this state statute, Section 70A, is not preemptive insofar as it pertains to the transportation of waste. The fatal flaw of this argument is that that this statute 70A has nothing to do with the transportation of waste. The town's relying on the legislative history, as well as this AGG case, the Ninth Circuit case. The town says that the FAA only preempts state laws regulating the routes and services of motor carriers transporting property. And according to the town, garbage is not property. Well, in support of this argument, it cites the House Conference report. But the report states, the conferees further clarify that the motor carrier's preemption provision does not preempt state regulation of garbage and refuse collectors. It's not preempting garbage. It's garbage and refuse collectors. Section 70A, however, is not a state regulation of garbage and refuse collectors. It's a statute that regulates the routes and services of a motor carrier that happens to be organized as a railroad corporation. It has nothing to do, 70A has nothing to do with garbage collection. 70A applies to any freight. It applies to cranberries. It applies to gold bars. It applies to municipal solid waste. The only distinction in this statute is whether the motor carrier is owned by a Massachusetts Railroad Corporation. Simply put, if a non-railroad corporation were trucking the town's municipal solid waste to the CMAS facility, the statute wouldn't even apply. And that's why this statute cannot be viewed as a statute regulating the collection of garbage. It's regulating railroad corporations operating motor carriers, and by the express terms of the state statute 70A, it is preempted.
So you're not a refuse collector?
Absolutely not, Your Honor.
Even though you pick it up and you put it down,
No.
so to speak?
And I think I was encouraged not to say one person's trash is another person's treasure, but I think, Your Honor, it really does, the statute does talk about refuse, or the Ninth Circuit case, and as well as legislative history, is addressing garbage refuse collection. And Congress didn't define property in the FAA, and it didn't explain necessarily why, let me back up. Property denotes an ownership, an item of ownership. And garbage, when it's at the collection, is really, there's a notion of abandonment of it here. But Section 3, and this is why it is treasured to some extent, Section 3.1 of the Waste Acquisition Agreement, that's the agreement between the town and between CMAS, specifically discusses the transfer of ownership of that municipal solid waste from the town to CMAS. When Bay Colony was transporting that, it was a commodity that was owned by the town, and then when it got to the facility, it was transferred upon acceptance to the CMAS facility. And indeed, this commodity, this property, had value. To CMAS, it was fuel to be converted into energy, and CMAS was willing to give value and consideration for that fuel. Indeed, it was property to CMAS, and it was critical to their operations. So, Your Honor, in short...
Just to address this, I don't know if you had a chance to see the Massachusetts Delivery Association versus Martha Coakley case that just came out of the... And so could you address that?
Absolutely. I think, Your Honor, what you're perhaps referring to
the
is... the last paragraph, which in dicta, I think it's not addressing at all. This
excludes statutes that affect motor carriers' transportation of passengers, statutes that affect a motor carrier's transportation of garbage.
And garbage. And I think it's dicta, and it goes back to the same analysis of the Ninth Circuit case, AGG, and it also goes to the legislative history. But I think it's really dicta because in that case, it was really not dealing with an express preemption situation, which we had here. It was dealing with a wage act, which they were trying to say reaches as far as preemption.
Now, have we a principle that we preempt as little as we can?
Say that, I'm sorry, Your
Do
Honor.
we have a legal principle that says we apply preemption sparingly so that we preempt only what we have to preempt?
Fair enough, but I think what we do is we look at the statute, the four corners of the Massachusetts statute, and we look at the FAA, and we look at the case law of the Supreme Court, which outlines what is this analysis? What is the analysis that we go through? And there's not a public policy exception or a public safety exception to this preemption. There are specific exemptions in the FAA that are dealing with motor vehicle safety issues specifically targeted, and that is applicable, Your Honor. Those are the exceptions, but it doesn't go so far as to say there's this broad state police power that is you can't touch. So while we respect states' rights and the ability, Congress has spoken here, there needs to be a uniform application of the laws here in a level playing field for all motor carriers. And singling out a motor carrier that happens to be organized as a railroad corporation, that happens to be hauling municipal solid waste, and if it was hauling cranberries, then it wouldn't be applied. That is a stretch, Your Honor, that I don't think is applicable here.
Thank you, counsel.
All right, thank you.
Thank you.